and welcome to a Montana Human Rights Bureau presentation on sex discrimination. In order to understand sex-based discrimination specifically, you must first understand what discrimination is generally. So what is unlawful discrimination? Unlawful discrimination can be simply defined as an adverse action taken in a protected area against an individual because of his or her protected class status. To help us better understand the definition of discrimination, we're going to break down and define some of its terms. This slide shows a list of the protected areas under discrimination laws that the Bureau enforces. They include employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes. But note that Montana law recognizes the additional protected classes of creed, marital and familial status, and political belief, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Sex is a protected class under federal and state laws. The federal law that prohibits sex discrimination in the area of employment is Title VII of the Civil Rights Act of 1964. Montana's Governmental Code of Fair Practices and the Montana Human Rights Act are the state laws that prohibit sex discrimination in the various protected areas seen here. Someone is a member of the protected class of sex by virtue of being either male or female, and are accorded all the rights afforded to the protected class. Generally, these types of cases will assert that the charging party was discriminated against or treated differently just by virtue of being a male or female. For example, a man may assert he was denied a job because he is a man after being interviewed by an all-female panel who then selects a female candidate for the position. The protected class of sex also has several subcategories. Sex stereotypes is one of those subcategories. For some time, the U.S. Supreme Court has recognized that someone can be discriminated against because they do not conform to the sex stereotypes others feel they should. In the landmark United States Supreme Court case, Ann Hopkins was passed over for promotion multiple times despite her job performance because she did not act or dress feminine enough. She was advised that she would have a better chance of being promoted if she were less aggressive and wore makeup and jewelry, among other suggestions. Her employer discriminated against her by failing to promote her based on her not fulfilling the stereotype of how they expect a woman to act or look. Other subcategories of the protected class of sex include sexual orientation and gender identity. Under the landmark United States Supreme Court case Bostock v. Clayton County in 2020, the court determined that the protected class of sex under Title VII of the Civil Rights Act also includes sexual orientation and gender identity. Under this holding, an employer cannot take an adverse employment action or harass an employee based on his or her gender identity or sexual orientation. Pregnancy is also included as a subcategory of sex, since only females can be pregnant. The Montana Human Rights Act sets out specific obligations for employers with pregnant employees, which will be reviewed in a bit, but as an example, a sex discrimination case was filed at the Bureau wherein the charging party was fired after requesting additional maternity leave when she needed surgery and recuperation time for a condition she developed after giving birth. The Montana Human Rights Bureau investigates sex discrimination cases, including all of its subcategories reviewed here, in all of the previously mentioned protected areas, not just employment. So now that you understand what is included under the protected class of sex, we will next look at the types of discrimination cases seen here at the Bureau. Whether or not someone is a member of the protected class of sex is a threshold issue, the first element, but not the only element, that must be satisfied when determining if sex discrimination occurred. Sex discrimination can take several different forms, including disparate treatment, harassment, pregnancy, by association, and in an indirect way, retaliation, when someone opposes sex discrimination. We will now review each type of discrimination as it relates to the protected class of sex. Disparate treatment cases allege that a respondent treated a charging party differently than others based on his or her protected class. The first step of a sex disparate treatment case is the prima facie case. Prima facie is a Latin term that means on its first appearance. The charging party must prove each element of a prima facie case to show that what respondent did, the adverse act, looks like discrimination on its first appearance. The first element requires the charging party prove that he or she falls under the protected class of sex. Next, the charging party must show that he or she was subjected to some type of bad act by respondent. And lastly, the charging party must prove that there is a connection between his or her membership in the protected class and the act taken by respondent. Some evidence that raises a reasonable inference include that the adverse act does not happen to those who are not in the protected class of sex like charging party, or comments that suggest sex was a factor in the act. When analyzing disparate treatment cases, a shifting burden analysis is used. As we just covered, in the first step of analysis, a charging party has the burden of proving the elements of a prima facie case. After the charging party meets that burden, the burden then shifts to the respondent to produce a legitimate, non-discriminatory reason for the adverse act it took against the charging party. Once the respondent produces that legitimate, non-discriminatory reason, the burden then shifts back to the charging party to prove that the reason offered by respondent is pretext or unworthy of belief. In order to prevail on a disparate treatment complaint, a charging party must prove his or her case by a preponderance of the evidence. This means that the discrimination more likely than not occurred. This standard is less onerous than beyond a reasonable doubt or based on clear and convincing evidence. Rather, it is a 51% probability based on the evidence at hand that discrimination occurred. It's important to note that the administrative rules of Montana change this analysis a bit in the event that there is direct evidence of discrimination. When there is direct evidence, there is no shifting burden, but rather respondent must prove by a preponderance of the evidence that an unlawful motive played no role in the action it took against charging party. In the alternative, respondent can prove that the direct evidence is not credible and unworthy of belief. An example of direct evidence would be unwelcome sexually explicit text messages sent from one coworker to another. We will now walk through a case example so you can see the shifting burden in action. A charging party filed a sex disparate treatment case with the Human Rights Bureau against his employer, a school district where he was a janitor. He alleged his female supervisor regularly assigned tasks to him that were more physically challenging, like stripping floors and cleaning carpets. Charging party noted that his supervisor would comment to him that because he is male, he is stronger and faster. Walking through the elements of the prima facie case, charging party is a male and therefore a member of the protected class of sex, satisfying the first element. Charging party asserted the majority female custodial staff did not want to perform certain duties, which were then assigned to him. Specifically, on June 11, 2018, charging party was told to go lift the cafeteria tables and clean the floors in the middle school commons because he is a man and can do it faster than the females who were previously assigned the task. So charging party was subjected to an adverse act and satisfies the second element. Furthermore, the supervisor's comments about charging party being assigned additional and more physical tasks because he is a man raise a reasonable inference that charging party was subject to these different terms and conditions than his female counterparts because of his sex. Thereby, he satisfies the third and final element of the prima facie case. When the burden shifted to respondent, it denied charging party was targeted in this manner or that the comments were made. Instead, it said that the assignment to lift tables and clean floors on June 11, 2018 was made to charging party's team and not just him. Respondent pointed out that charging party's team was not entirely male. Then it was up to charging party to show respondent's reasons were not worthy of belief. First, the investigation revealed the charging party's team did have one female on it, but she was absent the day of the June 11th assignment. One of the male custodians on charging party's team heard the supervisor say that since charging party was male, she could really use his muscles. This same male coworker is currently the only male custodian at the school and now feels he is being targeted as well with extra duties. With this evidence, charging party was able to overcome respondents' legitimate, non-discriminatory reasons. Ultimately, the evidence showed that respondent did assign more arduous, less desirable tasks to charging party because he is male. Harassing someone or creating a hostile work environment for someone based on any protected class is unlawful, including sex. Harassment can take many forms, and the different categories under sex that we reviewed earlier apply here as well. So, for example, someone can be harassed based on their sex, their failure to conform to sex stereotypes, their sexual orientation, their gender identity, or their pregnancy. It is also important to note that someone can be harassed by others of the same sex as well. The legal framework for a harassment complaint can vary based on what protected area the discrimination occurred in. As you can see here on this slide, the elements are different for harassment or a hostile work environment complaint that occurs in the area of employment versus harassment that happens in the area of public accommodation. As it relates to the protected class of sex, generally speaking, a charging party must show that he or she is a member of the protected class of sex who is subjected to either offensive or hostile conduct because of their sex. Many times, the conduct comes in the form of comments or unwanted touching. After the charging party establishes that, the remainder of the elements left to prove depends on what protected area the discriminatory acts occurred in. Regarding the last element in the area of employment, how this is applied depends on who is engaged in the harassing behavior. For example, if the harassment is being carried out by a president or owner, the business respondent is always liable. However, if the harassment is carried out by a coworker or non-employee, the business respondent is only liable if it knew or had reason to know about the harassment and did not take prompt corrective action to stop the harassment. As mentioned earlier, the protected class of sex includes pregnancy. This means a pregnant woman cannot be treated differently than others because she is pregnant in any of the protected areas reviewed earlier. The Montana Human Rights Act also lays out certain restrictions for employers when dealing with pregnant employees. Under the Montana Human Rights Act, an employer cannot terminate a woman's employment because she is pregnant. Also, an employer cannot refuse reasonable leave for the pregnancy, nor can it require mandatory maternity leave for an unreasonable length of time. An employer also cannot deny any accumulation of pay or leave benefits as accrued by a pregnant employee if that employee is disabled as a result of pregnancy. And lastly, an employee who takes a pregnancy-related leave of absence must be reinstated to her original job or an equivalent position with the same pay, benefits, and seniority once she expresses an intent to return to work. It is interesting to note that someone can also file a discrimination complaint for disparate treatment or harassment if they are treated differently because of their association with a person who is a member of the protected class of sex. This type of complaint is called by association. An example would be an employer refusing to hire an applicant because the applicant has a transgender child. In this example, the applicant is being treated differently or less favorably because of his or her association with a person in the protected class of sex. Likewise, someone could possibly file a by association complaint if their coworkers repeatedly mocked or teased them because their child was transgender, as that would be creating a hostile work environment based on the child's sex. Retaliation is the second highest number of filings received by the Bureau each year. It is important to note that retaliation is its own creature, so to speak, rather than a subcategory of sex discrimination. It is a bit indirectly related to sex discrimination. Unlike most other forms of discrimination, the person being retaliated against does not have to be a member of a protected class or associated with a member of a protected class. Here you see the three elements that constitute a prima facie case of retaliation. Retaliation is when a respondent takes a significant adverse act against a person because he or she engaged in protected activity. Protected activities include opposing or objecting to discriminatory acts, participating in an investigation or case of discrimination, and requesting an accommodation. For example, if an employee complains to their boss that they don't like that their coworker is being harassed because she's a lesbian, the employee has opposed sex discrimination and engaged in a protected activity. Likewise, if the employee acts as a witness in the employer's investigation into the harassment of the coworker, the employee has engaged in a protected activity. When determining whether or not the charging party was subjected to an adverse act, the question revolves around whether or not the act would dissuade a reasonable person from engaging in protected activity again. Continuing on with the example just discussed, if the employer gives the employee who reported harassment and participated in the investigation into harassment a poor performance review or a demotion because the employee engaged in protected activity, the employer has then retaliated against the employee. It is reasonable to think that a demotion or a bad evaluation could dissuade the employee from speaking against discrimination again. You should now have a basic understanding of discrimination laws regarding the protected class of sex. Additional, more in-depth trainings on topics covered in this training, such as harassment and retaliation, can be found in another training video offered on the Montana Human Rights Bureau's YouTube channel. For more information about discrimination or the Bureau, please visit our website at www.montanadiscrimination.com or call us toll-free at 1-800-542-0807 or locally at 406-444-2884.